file and review this, and it's a lengthy file. And I can't help but feel that the children have been lost in this case. The he said, she said, he's not doing this, we need more of this. Where are the kids? Well, right now they have an arrangement that seems to be working okay. But as we already know, there's a history with this case. It started off with the pendulum pretty far tilted in one direction. But things have drastically flipped back, and they seem to be balanced now. But Mr. Vining still has concerns. He's not raising his voice or becoming more involved in this process because he shouldn't be, because he doesn't care. It's because he cares. He cares about what happens to these children. And I understand that Ms. Frazee did what she had to do in her legal opinion to file this motion because she feels this man needs to be restrained. But I don't believe putting a muzzle on the dog is necessarily what we should be going for here. Giving him some direction to go about this. As you said, I mean, criminal contempt proceedings would obviously hinder and obstruct the process. Civil, okay, let's talk about what that means then. MCL 600.1701. Disorderly, contemptuous, or insolvent behavior. That's what you talked about. Ms. Frazee put in her motion that his behavior was unreasonable. Unreasonable. But it's well established that attorney fees are not generally recoverable, as contempt or otherwise, as an element of cost or an item of damages, unless expressly allowed by statute or court rule. That case is Mattress vs. Amical Oil Co., 424, Mitch, 675, from 1986. Opposing counsel cites no court rule or statute in her motion.
Wait a minute, what did he say?
MCL 600.1701. Disorderly, contemptuous, or insolvent behavior. That's what you talked about. Ms. Frazee put in her motion that his behavior was unreasonable. Unreasonable. But it's well established that attorney fees are not generally recoverable, as contempt or otherwise, as an element of cost or an item of damages, unless expressly allowed by statute or court rule. That case is Mattress vs. Amical Oil Co., 424, Mitch, 675, from 1986. Opposing counsel cites no court rule or statute.
No court rule or statute. That means this shit is not even possible to happen. That means I shouldn't even be there right now, because if the judge is, oh, she's such a fucking detective when she's trying to figure out how she's going to label me wrong, that she's using shit that doesn't even apply for the circumstance we're fucking in. Then the chick doesn't have to, Frazee doesn't have to meet any motherfucking bar of elements, right? They don't have to follow process or do any of that, right? Then I want to point out something about this loud thing. In the front of the courtroom, the microphone is on the table. I wasn't seated towards the table the entire time. I was seated a little bit away from the table. I did this purposely because I didn't want to be like kind of within their reach or look over to my paperwork as I would shuffle through my paperwork. So when I began to speak, I would always move towards the mic and lean right over to the microphone. So if I sound louder, it's merely from leaning over to the microphone. But I like how the judge has tried to say, he was so loud and this and that. Okay, yeah, I would argue my points. And I did make statements about him being a coward because he did get loud. I'm going to buy and purchase that video of that recording, and I'm going to give it to the public. Because one thing that happened that day was I was there for more than 4 hours. So somehow I was able to be there for 4 hours, longer than any other person's testimony I've ever seen. No one else has been in court and seen a 4-hour testimony, right? Continuous, at no point in time, without representation by yourself. Nobody. But let me start this back.
In her motion. There are exceptions, of course, to this, and they are to be narrowly construed by the court. This is Brooks v. Rose, 191 Mitch App, 1991. It lists exceptions such as fraud. Oppenhusen v. Weinerstein, 2 Mitch App, 288, 1966.
funny he mentions fraud, because later Miss Malone was guilty of fraud upon the court, direct contempt. Furthermore, when we had that hearing that day, she lied over and over that day. So all of those lies were direct contempt. He did nothing about. I have the court videos. I'm going to play that hearing and dissect it this same way, because we're going to remember this video part where my lawyer is outlining that the fraud is like a special area, right? Where the contempt should get worse and you should be able to get your lawyer fees. That's what he's discussing right now, because I had to pay her lawyer for this, right? And when she was in contempt, she didn't have to pay my lawyer. But I'm always complaining about that fairness, equality thing, right? So she was guilty of fraud, one of those special circumstances. Let's get back to that.
Malicious prosecution, Tutton v. Olson and Eban, 251, 642, 1930. False imprisonment, Bates v. Kitchell, 166, Mitch 695, 1911. Fraud, malicious prosecution, and false imprisonment. These are the limited exceptions that you think of, that the court has thought of when you think of the imposition of attorney fees beyond court rule or statute or contract.
Fraud, false
So
imprisonment.
the threshold issue in deciding any award for attorney fees is based on this. What is the basis? And in this case, we're going for limited circumstances. And the court is to construe that narrowly. I don't believe unreasonable conduct is the type of behavior that has been encompassed when they reference these limited circumstances: fraud, malicious prosecution, false imprisonment. These are big things.
Unreasonable behavior. See, what the reasonable behavior is allow myself to be violated, not defend myself, to feel like I'm being insulted and not say anything back. The idea that I can't say that someone's talking loud to me or bullying me, that I can't say that, and then you can decipher that yourself and say, oh, no, they're not talking loud. That's why I need to get that recording and put that recording out. We'll decide if the referee was talking loud to me. We'll decide whether or not I had answered questions. And we'll also decide whether or not all my business associates need to be named when I'm speaking in custody court. Like,
The fact that she couldn't get him to answer the question that she wanted regarding his business interest and things like that. I don't know why the record is devoid of any discovery request. I don't know why she sought to impeach him on things she did not have to question him on.
oh, yeah, that's another
That's
thing.
how you should have gone about this.
That's another thing. Anytime I disagree with some shit, I have to come back to court and impeach somebody, which I've done before. They don't have to do that shit with me. They get to just say shit about me and it just rolls. So yeah, it gets to a point where you're highly agitated. When I look back at my court videos, I can tell, I really can tell in looking at myself, the difference in how I feel. At this point, I can see where I'm like, oh, this is a bullshit exercise all the time. Because at this point, I had already come back to court for numerous false allegations. She had brought me to court for 2 PPOs, one of which she didn't serve me, the other which she marked every square and could not prove anything, and admitted on the stand, I have this video already, she admitted on the stand she only did it because the friend of the court told her to do it to withhold her information, to make it so she could keep her information private.
It should have proceeded. If she didn't believe his answers, that's impeachment. I will show you. That didn't happen here. She complains that his testimony was too lengthy, that he took too much time. Well, as you noted, he had to re-testify from the February hearing. And we can't say, well, we have to consider that. He should have sped it up.
Oh, yeah, that's another thing. I got to redo everything, but I got to do it faster. So when they say lengthy, it's only lengthy because they're asking me shit that we had already covered in the old hearing. He just didn't record it, so now they want me to re-speak about everything, right? And that's not my fault, that's their fault.
He was careful to take time, because in his experience, it has been unfortunate that these proceedings have not been recorded. And so when he took issue with being mislabeled defendant and plaintiff, that was important to him, because he feared that the worst case scenario is exactly what's going to happen. I'm going to request a transcript, and it's going to be all mixed up because I didn't take the time to get this right. He had some choice words that you referenced that he exchanged with the referee. And I've talked to him about this, and he's assured me that, yeah, you know what, I could have gone about that a different way, but I didn't know what to do. I kind of just was speaking because I was so impassioned in the moment. But that's not who he is. And if he had had his attorney there, if I had been there, I would have been sure that wouldn't have happened. The other factors that we need to consider in deciding on the award for attorney fees and whether this is going to play into contempt. We have to look at ability to pay.
Also, I want to point out something here as I get ready to finish this up. She made a decision before my attorney even argued. She started off court reading off notes and why she was going to hold me in contempt. That's how she started court. So my lawyer is already making his argument from me being guilty. That's what the argument is being made from right now, from me being guilty.